No, it's because look up on here. Very intriguing. Right now, my desk.
Actually, the slides, when you're actually viewing the video, they're backwards on this monitor. View of it. Don't ask me to explain that, but that's how they are.
Yeah, they did insurance defense and all the defense family adoption. I know mainly insurance defense. No, I don't. I think. Oh, okay. Oh, yeah. They felt they could pass it. Like, they even gave them like an extra while. Okay. Because I was like, it's not. Oh, that's fine. He called you. And then we got it. For a year. So I could bail. Okay. Oh yeah. Where is he working every day? Yeah, I still do his leaders. He has a leader. Private profile and then he It's very nice. And like last there. Oh my God.
More expensive. Are you ready, Shasta? I think we should get going. Hi, everybody. We're going to get started because we applied for an hour of CLE credit. And so we need to get on with the programming. So thank you all for being here. It's great to see you, especially a lot of people. At least they're new to me. Before I introduce our speaker, I want to make a few announcements. The next Lunch and Learn is a breakfast, just to keep things exciting and confusing. It's on April 15th, and I think this sounds pretty good. It's preparation for the 5K that the Access to Justice group is having on May 16th. So IWL is putting together a team, but if you wanted to come and not be part of the team, that's fine too. So it's a nutrition and exercise breakfast that's going to be in Holland and Hart on April 15th. So keep a lookout for that in your emails. Also, I want to take a minute to thank Dean Larson, who is in the back of the room. A lot of you probably don't know Dean, but he's been really helpful to IWL in getting the webcast going. So if you notice on the announcements, we have a YouTube channel, so you can tune in and watch some of them, not all of them, depending on the subject matter and how comfortable people are. But and then they're available on the YouTube channel even after the program. So Dean helped us get that going, and occasionally when we don't have enough people to help get it set up for a given day, Dean will come and run the laptop for us too. So I just want to say thank you to Dean. Also, the Lunch and Learn Committee is always looking for ideas. And if you have any ideas, or you yourself might want to be a speaker, please email. You can email me. You all have my email because you RSVP'd. And we take those ideas into account. You're welcome to join that committee as well. It's a very fun committee. And basically we vote. We get all these ideas and we take a vote. And that's how we decide what the programming is. So it's very democratic. And we love all the ideas that we get. So if you want to join the committee or just submit an idea, let me know. So now on to today's programming. We are very fortunate to have in our very own backyard a very talented writer, Shasta Kilminster Hadley. She's a Deputy Attorney General at the Idaho Attorney General's Office. She's also an adjunct professor at Concordia, where she teaches courses on, get this, legal research and writing, intensive legal writing, rhetoric and legal persuasion, and water law. So she is a very busy woman. She has her JD.
Not all at once.
Not all at once. She has her JD from Arizona College of Law, and she served as the senior articles editor for the Arizona Journal of International Comparative Law, and she was awarded an Outstanding Writer Award. So she's very qualified to teach us some tips about good writing. And I have been through this training with her, and so that's why I suggested that this group might like to have a training. I can vouch for it. It's very good. So with that, I will turn it over to Shasta. Thank you.
Well, thank you for having me. I'm always happy to talk about writing, and I can be a bit of a nerd about it. So if you start nodding off, I'll know that I've gone too far into compound constructions or something like that. For the past decade or so, the trend in legal writing has been to simplify. Looking at faces, I can see that there are lots of people who are young enough to have, sort of gotten the beginnings of that trend in law school. But for many years, lawyers read the law with these old archaic cases and these judge decisions that were sort of packed with as many big words as you could fit into a paragraph, with this idea that lawyers should be writing in a very lawyer-like way. And if you ask some older attorneys, they'll actually tell you about experiences as first-year associates going in and turning in briefs and having them turned back and said, this isn't lawyer-like enough. Go ahead and make it more convoluted and complicated and hard to understand. Nowadays, that's just not the case, both from the level of education in law school through clerkships and from the judiciary on down. People are looking for simpler legal writing. They want basic language. They want us to cut out the multiple syllabic filler words and make legal writing easier to understand. So that's what we're going to do today. We're going to be focusing on a sentence level. So, obviously there are more macro ways to make your writing easier to understand. Things like not including 15 issues on appeal when you can include your 3 strongest instead. That's topic for another day. But we're going to be looking at word choices and how sentences work together and how to make your briefs more readable. And feel free to interrupt me for questions. Well, don't interrupt. Raise your hand. All right. So this is an example, and I know that you can't, I don't expect you to read all of these words from back there, but this is an example from a U.S. district case in Florida in federal court, Belly versus Hedden Enterprises. And what happened here was the plaintiffs filed their motion to file an overlong brief. They could file a 25-page brief. They filed a motion to file an overlong brief and didn't wait for the court to grant it and just filed that along with their memorandum. And this is the opening paragraph of their memorandum. And I'm not going to read it all to you, but just in the first couple of lines, you see plaintiffs, Belly, Peterson, Kinsey, and Johnson, individually and on behalf of all others similarly situated. You see the hereinafter referred to as, by and through the undersigned counsel and pursuant to. It's pretty wordy. So what the court did here is it issued an order denying their motion for an overlong brief and struck their memorandum in its entirety, saying this: a review of the proposed 29-page motion's commencement confirms that a modicum of informed editorial revision easily reduces the motion to 25 pages without a reduction in substance, concentrating on the easier to read and much shorter. And this is really the trend that we're seeing today. So that was Extreme Makeover number 1. I like to show these just because they're kind of fun. They get your brains working. Let's see if we can make these sentences into something short and sweet. So the first one here: aqueous fluids exhibiting non-agitated surfaces generally extend downward to considerable depths. Can anybody shorten that for me? Edith?
Water flows downhill.
Close. You're getting there. Something pretty similar. Anybody else? How about still waters run deep? Concrete mineral matter moving forward with a revolving motion fails to collect an accretion of bryophytic plants.
A rolling stone gathers no moss.
Excellent. All right, see now that we're starting to work. Okay, very good. But writing simply is not just a matter of style. People also want to avoid orders. So this is an order issued in a U.S. bankruptcy court in Texas. And the order is entitled, "The Order Denying Motion for Incomprehensibility." And there's some really funny stuff in this order from the judge, but all I have here is the title of the motion so you can get an understanding for why the judge did this. And this motion is entitled, "Defendant's Motion to Discharge Response to Plaintiff's Response to Defendant's Response Opposing Objection to Discharge." So, understandable that the judge denied this motion. And actually, the judge in this case put a footnote on the end of this that basically told the plaintiff that reading motions such as the plaintiff's had rendered him dumber than he was before, and quote, merited this kind of footnote. All right. So the first thing that we're going to do is we're going to talk about the verb. And the reason that verbs are so important is because everything that we do, every case that we have, it doesn't matter if you're in bankruptcy or if you're in criminal law or if you're doing civil litigation, involves somebody doing something, wanting to do something, having done something, failing to do something. It's all about what happened or didn't happen. So one of the easiest, in fact, the easiest and most effective way to strengthen your writing and to simplify it is to edit out weak verbs. There's a couple of different ways to do that. We're going to talk about passive voice. Everybody groan now, get it out of your system. And we're going to talk about nominalization, and we're going to talk about subjects and verbs and their relationship. Okay, they like to be together. So passive voice, everybody here is Charlie Brown's teacher when people talk about passive voice. This started when you were in middle school probably, and continued all the way through law school, and probably even in practice with people striking out things that you just aren't quite sure why they're passive. We're going to talk about it today because it is important. It's easy to think it's not important because we read so much passive voice, especially if you read outside of the law, if you read novels. There's beautiful uses of the passive voice, but it's not strong, it's not active, and it's not persuasive unless you use it very thoughtfully. We'll talk about the uses for the passive voice here in a minute. Just to underscore that point, in this case, this was federal court in New Hampshire. This court actually dismissed the complaint that was filed because it used the passive voice. Why? Because there was no theory of causation. He said the use of the passive voice here clarity was manipulated, obscured the connection between the defendant's action and the plaintiff. Now, you don't want to take that back to your high-paying plaintiff, right? After you put in those hours to file that complaint. So, how do you recognize passive voice in your writing? Passive voice is always going to be a conjugated form of to be and a past participle. Okay, so some examples. It was held that. The complaint was filed by. You know, and as you read these, I want you to just sort of honestly in your head, nobody needs to make a big confession here, but honestly in your head, recognize how often we write this way and how often we read other attorneys' writing. These aren't sentences that we would say, ooh, that's a terrible sentence, right? We see them all the time in legal writing. The ruling was made by the judge. It is said that justice is blind. So when you find that to be conjugation and the past participle, you know you have the passive voice. My students at Concordia like this way of looking at it better. If you can add those words after your verb, you've got a passive sentence, or you've probably got a passive sentence. So the decision was made. If you can insert by zombies, then you've got a passive voice. Okay? How would we change this bottom sentence here to an active sentence? What is the key verb here?
The zombies decided to turn.
Okay, very good. The fact that there was a decision, right? Especially if we're dealing with regulatory boards or employment cases, the decision itself and making the decision is important. So the zombies decided. What would be another way to say this if we didn't need to put an emphasis on the decision-making process?
The zombies terminated.
The zombies terminated Mr. Johnson's employment. Okay, very good. Any questions about that? So how do you fix it once you've found it? Okay. The first thing that you do is you need to construct something that has a subject, verb, object order. All right. It's very basic, but because it's so basic, most of us don't think about it that way. It's pretty mechanical. You need to make the actor the grammatical subject. Okay. So if I tell you the cat was chased by the dog, instinctively our brains think that this story is going to be about the cat, right? But who's the actual actor? The dog, right? Who's doing the verbing? It's not really a word, so don't say verbing around anybody smart. Make the past participle the main verb. So you take that that decision, or I'm sorry, that was terminated. You take terminated and you turn it into just the present tense. Okay. All right, so here are some examples of fixing those. The ruling was made by the judge. The judge ruled, right? The complaint was filed by the plaintiff.
Plaintiff filed the complaint.
Okay, very good. How many of you have seen that at the beginning of a paragraph in your statement of facts or the statement of facts that you're reading from somebody else, right? It's really insidious because, again, there's nothing that screams this is wrong, because it's not wrong, right? It's just passive. Okay, the court held rather than it was held that. And this next one I like, I do government law, and so we have lots of discussions about agreements, right? And nobody can seem to figure out who wrote the agreement. Well, it's almost always going to be the parties. And even just by including the parties there, you've included that grammatical subject and you've made the sentence active rather than passive. Okay. So that's the good, the bad, and here's the ugly. I love this sentence because it's about, I mean, it's so passive, it's like unconscious passed out on the floor. It's so passive, right? It was alleged that the victim had been shot by the defendant who had earlier been detained and subsequently released by the police. Okay, nobody's doing anything actively in this sentence, right? It was alleged. By whom? Do we know? okay? That the victim had been shot by zombies, right? And the defendant had earlier been detained by whom? Okay, by the police. So this is all in passive voice. How can we rewrite this one? I'll give you a hint. It's easiest probably to start at the bottom of the sentence and work your way backwards. So, the police detained and then released the defendant who later allegedly shot the victim. Okay, much clearer. And what else do you notice about it just with this visual? It's much shorter, okay? Why is it important? Why would that be a benefit?
Page limits.
Page limits, right? That's the most obvious benefit, is that if you're going to run up against page limits, then, 18 sentences that you can shorten by this many words is going to yield you at least half a page, okay? But the other thing that makes it a benefit is that shorter really is more desirable for judges and their clerks to read, okay? We're not talking about opposing counsel, because maybe you don't care if you bore them to death by trying to fish through your convoluted sentences, but you want the judge and you want the judge's clerks to be able to get through your points and your arguments and not feel like you're costing them minutes that they will never get back, okay? So short is almost always beneficial. When is it not beneficial? Well, if you have to explain something and you don't do it adequately and completely because you're trying to write so briefly, that's a problem. But if you can explain something completely, if you can flesh out your argument adequately, then doing it with fewer words rather than more words is almost always a plus. Okay, another version of the ugly. A duty of care to the plaintiff was breached by the defendant when the slippery floor was left unmopped by the defendant. Who wants to give that one a whirl? This is the problem with CLEs given by people that actually teach. I ask questions and then wait, yeah.
The defendant breached his duty to the plaintiff when he left the slippery floor unmopped.
Excellent, okay? And I've done it in almost exactly the same way. I've just put those two clauses in a different order, but that doesn't change the meaning, and they would be just as effective in the order that you stated them. When the defendant failed to mop the slippery floor, he breached his duty of care to the plaintiff. Okay? This one isn't that much shorter. It's a little shorter, but it's a lot more clear. And why is it perhaps more persuasive?
What gives a nexus between the duty and the breach?
Exactly, and who did it, right? So if theoretically, you are probably writing this because you want the court to believe that the defendant should be held responsible for this. So when we make this active transition, we are creating a very close link between the defendant and the action, right? Nobody else could have done it. So it's really important to remember that you're not just writing for simplicity, but you're also writing for persuasive effect. All right. Now, when we talk about that persuasive effect, there is a rationale occasionally. It doesn't happen too often, but occasionally for using the passive voice as a persuasive tool. And that's when we want to do exactly the opposite of what I just described. When you want to create a space between the defendant or your client and the action that took place, right? When you want to distance that. And maybe there's no distancing it in reality. I mean, you're not trying to hide something, but what you're trying to do is discuss the facts. You're trying to discuss what happened in such a way that doesn't put your client at the center of all the bad actions, okay? So consider this sentence from the plaintiff's statement of facts. Following Mr. Johnson's report of sexual harassment, Ms. Lockley decided to terminate his employment. So who do you suppose is the bad actor from the plaintiff's perspective? I heard a whisper. Okay, Ms. Lockley, right? So if you're Ms. Lockley's attorney, you might want to distance her from that as much as possible, okay? And in that case, the use of the passive voice allows you to do that. So the takeaway here is learn how to recognize it, okay? Learn how to recognize it. Once you've recognized it, then decide whether or not you meant to use it there, okay? Is this actually how I want to say this? Is there a rationale for me using the passive voice here? If there's not, then figure out how to fix it. Okay. Any questions on passive voice? The next thing we're going to talk about with regard to verbs are nominalizations. Does anybody know what a nominalization is? Ingrid?
So that would be adding TION to the end of a verb. So instead of saying he decided, you would say he made the decision. Is that what it is?
That's exactly right. So a nominalization is when you take, so the French word for noun is nom. If you turn it into when you take a verb and you turn it into a noun. So you're nounifying something, okay? What it does is it just waters things down, and you have to add extra words in order to be able to do that, okay? So we take a verb, we turn it into a noun, and as a result, you need an unnecessary verb to form the sentence, such as made the decision instead of decided, okay? An example, the police conducted an investigation of the allegations. Where is the nominalization there? Investigation, right? So how could you change it? How could you fix it?
Please investigate.
The police investigated, all right? And then you can eliminate a couple of extra words there, right? So how do you recognize nominalizations? Nouns ending in, and I'm not going to go through the whole list, in these suffixes are often nominalizations, okay? And you will find the addition always of that additional unnecessary verb. Okay, so in our previous example, it was conducted. Okay, we didn't need that verb there at all. We could just go for investigated. In the example that we had a couple of slides earlier, it was decided, right? Instead of just terminated. Or, sorry, made the decision instead of decided. So the fix is to turn nominalization back into a verb and to use a concrete subject. As an example, the department made the decision to deny the permit. How can we take, let's take it just a half step first. So how do we first make the decision an active verb?
Decided.
Okay. The department decided to deny the permit. So we've already removed two words there, right? How can we go further? Exactly, department denied the permit. So if all you're trying to get to is a factual statement that the department denied the permit, you don't have to make any sort of point about, the decision-making process. The sentence on the bottom is a whole line shorter than the sentence on the top, right? And easier to understand. If you have to include that decision-making aspect, then the middle sentence is still a more active, clearer, easier to understand version of sentence one. Is sentence one wrong? No, it's not wrong, okay? If you read that in any brief or judgment or in a book, it's not wrong. There's nothing incorrect about it. It's just not very persuasive and it's not. So here's an example of nominalizations all over the place. The actions of the transit authority in firing appellants for criticizing fare increases were a violation of the appellant's First and 14th Amendment rights. How many people look at this and say, that's exactly how lawyers write? I look at it and I say, that's exactly how lawyers write. What could we do to fix it? First off, where are our important important verbs that have become nouns?
Firing violation.
Good. So in firing, right, the noun there is, if you want to hear it a different way, is the firing, and you'll see that in a lot of legal writing too. The firing of appellants by the, so you can do a nominalization and passive voice all in one crossword, were a violation. How are we going to fix it? What did the transit authority do? Ingrid?
You could say by firing the appellants for criticizing fare increases, the transit authority violated the appellants' First and 14th Amendment rights.
Yes, absolutely. That would be one way to do it. So key in especially on that last part, violated. Okay, the transit authority violated. How could you do it even more simple? Or we're thinking how grade schoolers speak rather than even how, I don't know, lawyers speak. How about it violated their rights when it fired them? Okay, so either way, Ingrid's rewrite would work in terms of removing the nominalizations. This rewrite works. Is there any benefit to taking it to this simple a level, speaking linguistically? Not necessarily from a readability perspective, but from a persuasive perspective. You get a little bit more of a gut reaction when you say it fired them rather than by firing or in firing or something like that. It's a little bit more visceral. It makes it seem harsher, right? It's shorter, it's one syllable rather than two. So think about that with your word choices, because if you can say something, it's almost like saying something more baldly, okay? You just come out and say it. Boom, they fired me. So think about that in terms of persuasion as well. All right, subject and verb placement. I'm not going to spend time, but the reality is that subject and verbs are like long lost lovers. They just want to be close to each other. Okay? And the reason that they want to be close to each other is because it makes an entire sentence more readable. The whole point of your sentences are who did what. Now there might be other dependent and independent clauses in there that help explain or describe who did what, but the fundamental bottom line is who did what. Okay? So when you have a subject and it's separated by 2 or 3 independent clauses from its verb, what happens to your reader? Because we've all read sentences like that.
They fall asleep.
They fall asleep. Okay, that's a possibility that by the 3rd independent clause they've fallen asleep. Or more likely, what they've had to do is they've had to read the sentence and get to the verb and then go, oh, and start back at the beginning of the sentence, okay, and try to figure it out. You don't want your judges and you don't want your judges' clerks having to do that. It detracts from the readability and it detracts from your argument because it makes your argument seem convoluted. Even if your argument is actually pretty plain, if you write it in a convoluted way, it becomes a convoluted argument. So here's just a real quick example. You have the subject, which is what? Okay, and what's the verb? Held, all right? And you have this dependent clause in between them. This isn't an egregious example of this because the clause is pretty short, pretty easy to understand, but you can improve it as simply as just taking that clause and sticking it after the verb information. Okay. So the court held that the bicyclist must adhere to traffic rules, although it limited its holding to X, Y, and Z. Any questions on that? So when you're editing, when you've written your brief, you're editing it, start to pay attention to that stuff. And if there's a sentence that bothers you, or maybe it's something that you've sent out to your colleagues and everybody keeps coming back with some sort of weird comment about that sentence, you don't quite know how to fix it, take a look at where the subject is and where the verb is and whether or not you can make it simpler by sticking those together. Okay. All right. Shorter sentences are chic. Okay? So if you can take a sentence like this, the court in Juniper v. Jensen, a case involving a similar traffic accident, held that a person riding a bicycle must adhere to the same standards as a person driving a car, although it limited its holding to that case the fact that the bicyclist was intoxicated. Now, we're all smart people. We all read stuff like this all the time. We all understand this paragraph-long sentence, right? But if you can write with shorter sentences, it's going to be a lot easier to understand. It's also going to be a lot punchier. It's going to have much more persuasive effect. Juniper v. Jensen involved a similar traffic accident. Okay, now you've just drawn your judges' attention to the fact that, hey, this is something to pay attention to because this is precedent, right? The court held that a bicyclist must adhere to the same standards as a person driving a car. That's your main point. That's why you're pulling this case out, right? And then you say the opinion is limited to situations in which the bicyclist is intoxicated. So by putting that limitation at the bottom there, you've already kind of made your case. We have a little caveat at the end about when it applies, but the most important information was delivered with much more of a punch than it was in this big, huge, rambling sentence. Okay, so I'm 100% certain that none of you has begun a paragraph or a sentence in your legal writing with, because that would be stupid, right? But I'm 99.7% certain that all of you have used other throat-clearing expressions to start your paragraphs. What do I mean by throat-clearing impressions? Well, what is this? I think of like the short, portly, mustached British guy in like the 1930s banking commercial that comes in and says, oh, and it means pay attention to what I'm about to say, okay? It's gonna be important. Sit up and take notice. Common throat clearers are words like, it is expected that, it is significant, it is essential, it is crucial, it is worth noting, it is interesting to note. Those are all garbage constructions. Why? Because they don't actually say anything to the court or to your reader. You're going to announce that you're going to say something coming up here really quickly. So don't do it. Don't say it if it doesn't mean anything, all right? Announcing your intention to make an important point simply shows your reader that you don't trust them to recognize its significance. It also gives them one more chance to doubt you, okay? Because a legal reader, we're all trained to read things in a certain way. And we're trained to read them like we're assholes. Where everything that we read, we say, I don't know, is that true? Do I believe that? I don't know, is that right? And when you do something like this, you just give them one more opportunity to do that. You say, oh, is that really important?
Sometimes I do think that a judge is going to get like the most important facts. So I usually put like notably. Are those types of words the same thing? Because I mean, when you have the counsel saying that this doesn't matter.
To be brutally honest, yes, that's a throat clearer. It would be far more effective if you can highlight those with short, succinct, punchy sentences at the beginning, and if you can get away with it at the end of a paragraph. So when you highlight that right off the bat, and I'll give you an example with the next slide, okay? We all write things like this. It's important to note that Mr. Douglas knew he was diverting water from the wrong well. Now, if you feel very strongly that you want to put notably in there, notably is still way better than it is important to note just because it's one word rather than 5, right? That's fine. But if you just started off your paragraph, so if you're going through your statement of facts or if you're into your argument section and you start off a paragraph with, Mr. Douglas knew he was diverting water from the wrong well. That's pretty darn persuasive, okay? And the emphasis there is now directed towards knew rather than notably. So if you can, it's better just to try to do it with your writing than it is to add those throat clearing words. Let's see. So again, let's see where, okay. Again, not only are you using extra words that don't really say anything, you're not actually adding to your argument when you use these, but you're giving that judge a chance to say, I don't think that's so notable, or I don't think it's important or interesting.
How do you feel about if you cut the second sentence italicizing new? If you think that is so important, you want the judge to know, or?
You know, that's a great question. There are some people that just hate any sort of font changes for emphasis. I'm not one of them. I think if you use font changes judiciously, they can be super effective. And the reason they can be is because they do stand out. And they, in the same way that you would use the same, I think about it as how you would speak in oral argument, right? If you made this statement in oral argument, you wouldn't say, Mr. Douglas knew he was diverting water from the wrong well. You would say, Mr. Douglas knew he was diverting water from the wrong well, okay? So I would actually put that in italics if it were me. I wouldn't underline. I tend to prefer italics. I don't ever put things in bold for emphasis, and certainly not caps, but I would italicize new in this case. Okay, compound constructions are kind of like those throat clearing expressions in that they're groups of words that we stick together that don't really do much for us, all right? So there are all of these, gosh, I'm so smart, constructions that we stick into as many sentences as we possibly can if we're trying to emulate all of the old legal writers that we've read, right? By means of, by virtue of, in accordance with, in order to, for the purpose of. So let's think about some substitutions for these, and you'll see what I mean by them taking up space and being useless. Either one of those words will suffice here. Okay? In accordance with Idaho Code, blah, blah, blah. How about just under, okay? Even pursuant to is still shorter and sweeter than in accordance with. Anybody have a substitution for the second group? Two. And there's only 2 little letters in that one, right? Compared with all the other ones. By reason of, for the reason that, inasmuch as, because, and I've listed some other ones here. I'm going to run through them really quickly, but you'll be getting a copy of the PowerPoint so you can have these as a reference. Then, in the event that, anybody? This is my favorite. If. I love that because so many people say in the event that, especially in contracts, right? In the nature of. How about during the time that? When, while, or during, right? Depending on what your meaning is there. And about or concerning. So if you can replace these compound constructions with just a single word, it's almost always going to be worth it to do so because it makes your sentences clearer. Okay? Think about for a minute. I don't know if you do this still, but certainly when we were all sort of newish readers, and you'd go to the library and you'd open up a book and you'd see that it looked, pretty accessible visually versus there are like 8,000 words on every page here. I'm going to have to get a headache trying to read this. Having all these little compound construction words in your paragraphs, do that to your reader too, okay? You don't have easily accessible sentences, and visually inside your head, you do a little bit of a sigh because you know it's going to take a bit more mental work to get through those sentences. So if you can clean them up that way, it really is effective. Wordiness and legalese. Let's see, how are we on time? I'm gonna we're running out of time rapidly, so I'm going to speed up a little bit. Justice Scalia, a judge who realizes that a brief is wordy will skim it. One who finds a brief terse and concise will read every word. That's what compound constructions do to your brief. They make it look wordy, and they make us all do some skimming. What are we skimming for? Pardon?
The important stuff.
The important stuff, which is, somebody just said it. Substance, subjects, verbs, direct objects. Okay, that's what we're skimming for. And so the fewer other things that we have in our path, the better. So getting rid of that unnecessary legalese and wordiness will make your writing better. In terms of legalese that actually has some sort of a term of art effect, especially if you're dealing with a particular subject area. So if you're writing, you know, if you're writing about water and you're going to use some hydrologic terms, for instance, or contract terms, that type of thing, make sure that you see whether or not it passes the legalese test, okay? Because sometimes legalese is effective, right? If the legalese increases the communication between you and your reader, then it's worth using. But if it could potentially decrease it, then eliminate it for easier words. The best example I can give to you of this is if you're operating in front of a specialized court. Okay? So if I've got a water case and I'm trying it in front of the Snake River Basin Adjudication Court, I'm going to put in all those technical terms because I know the court understands them, and it'll hurry us along, right? Rather than trying to explain each one. But if I'm arguing the same stuff in front of the 4th District, where the judges have dockets that are full of all sorts of different cases and they can't really be specialized in any one subject area, I'm not going to use those technical terms. Instead, I'm going to describe these things in layman's terms. So this is a good test for deciding whether or not you're using terms of art correctly. Big words, add to wordiness, okay? I don't know how many of you do this, but I would be willing to guess that most of you do this because most lawyers do this. And that is that we start every sentence, if possible, with one of these multisyllabic connection words. However, moreover, additionally, nevertheless, nonetheless, furthermore, okay? Those are the words that a lot of attorneys actually write faster, type faster than any other words because we use them so much, okay? They do make you sound smart, but we know that you're smart already because you're lawyers, so you don't need to use them. And if you listen, actually get down to the business of understanding your arguments more quickly. So this is how Chief Justice Roberts wrote this paragraph, meaning this, he wrote it this way, not that way, when he was arguing the state of Alaska versus the EPA case before he was Chief Justice. You'll see that he replaces these big words with short, punchy, monosyllabic words. Okay, you still need those connections, right? Because you're connecting one thought to the next. But he uses but, nor, how, rather than the manner in which, and it makes it a lot more succinct. It also makes it more persuasive because it gets your attention when you start off a sentence with one of these short words. Who wants to argue with me about but being at the beginning of the sentence? Go ahead. All right. So the secret life of and but. This is the fun part of my presentation because it was such a revelation to me. But the whole and but not being at the beginning of a sentence is actually a big conspiracy that's generated by grade school teachers. And the reason that it's generated by grade school teachers makes sense. It's because as a pedagogical tool, when you're teaching small children to write, you have to have them avoid these. And if you don't, you get sentences like, I have a brother, period, and a dog, period, okay, but no cat, right? So they write incomplete sentences. But if you're writing a complete sentence, which means it has both a subject and a verb, and or but can be in front of the sentence, no problem. It is grammatically correct. Okay? With that said, you will find that there are lots of doubters out there in the universe because those grade school teachers are so good at brainwashing all of us. But you can verify it with any competent authority on grammar that you can use these. And plaintiff does not dispute that the judicial branch has never before in the history of the nation passed on such a question. Okay, that's Ted Olson writing. Richard Wiley, some of the best attorneys in the nation, but it is well suited that products in the same market need not be perfect substitutes for one another. So, what would you replace these? What would you use these in place of? Additionally, right? In addition, okay. None of us have a problem using those at the beginning of a sentence, right? Well, all and is a slimmed down version of additionally, right? Or put differently, however is just a bloated but. Okay, so replacements for common legal openers and transitions. Very quickly. What would you replace nevertheless and nonetheless with? Yet, very good. So, Kagan, Justice Kagan loves to introduce argument sentences with so, because it's just really punchy. Okay, intense writing versus writing with intensifiers. Moving right along, and I'm speeding up, I'm sorry, but intensifiers are just extra words that we add to make something seem more, okay? So instead of it being big, it's really big. The intensifier there is really. Writing intensely is more effective, and what that means is that you are using more punchy, more evocative words so that you don't have to add those intensifiers. Instead of saying it's really big or it's very large, you say it's gigantic, it's huge. It draws the court's attention to what you're talking about and actually can help you be more persuasive just because it evokes more, at a nuanced level of what you're trying to say. And intensifiers can hurt your credibility the same way that those throat clearers can. All right, they give your reader a chance to question. Okay, Mr. Smith's explanation is incredibly convoluted, right? It's a really nice way to put down your opponent's argument. And your judge is going to ask what? Is it really incredibly convoluted? I mean, maybe it's a little complex, but okay, the defense presents an extraordinarily complex argument. Is it really so complex as to be extraordinarily so? Be careful with these, because judges have actually written that they're kind of offensive sometimes. Because the idea is that you, as a judge, can't understand this without me telling you just how very, very tough it is to understand. And what's interesting, this is what I think is fascinating. Studies have been done on appellate briefs that show a correlation between the use of intensifiers on the losing side. Okay? So when people have weaker arguments, they tend to try to shore them up with a lot of intensifiers. And if you look at appellate cases where there is a dissent, in the decisions, both the opinion and the dissent will include more intensifiers because we just put them in there because it's really bad. It's not just bad, it's really bad, and you're trying to argue. So there's a correlation or there's at least a fair amount of studies that show that intense verbs are kind of used to put more certainty on something where the law is vaguer. So if you can remove them, you get more clarity. So just a quick example here. In a very short amount of time, the fire in the nightclub became incredibly hot. There's nothing wrong with this sentence, but you can make it shorter and sweeter by removing the intensifiers and using more evocative words. Okay. So for instance, you remember that case few years ago where that nightclub in, I think it was Rhode Island, burned. This type of language was really kind of got you. You felt like you knew what it was like there. Okay, sorry, do we need to stop or a few more minutes?
People can leave when they need to, but I think everyone is very interested, so keep going.
All right, double negatives. I don't know why lawyers like double negatives, but we do. And it's silly because we tell our kids not to use double negatives, right? But you'll often find things like this in legal writing. It is not uncommon. He was not incapable. It was not insignificant. All right, just don't do it, okay? It is common. If it's not uncommon, then what is it? It's common, okay? So yeah, if you could steer clear of double negatives, do it as much as you can. I like this. This is from legal writing in Australia. The first known case of a quintuple negative. The grounds of appeal announced on Monday state that Justice Sifris erred in not finding Mr. Goldberg was wrong in failing to set aside the summonses. Okay, so don't be that bad. Unnecessary repetition. What do you call a dinosaur with an extensive vocabulary? Thesaurus. What do you call a legal writer who uses repetitive synonyms or adjectives for every word? A legal writing dinosaur, okay? We use a lot of unnecessary repetition. If you can take it out, it's not as noticeable as a lot of these other flaws or more complications that we've talked about. But if you can remove it, you can simplify your writing. Cease and desist, okay? Stop, or either cease or desist, right? But you don't need both. Every town, city, and village, how about we replace those with municipality? Okay, find a word that will represent all of them. These are more common ones, past memories. I don't know anyone that has future memories. So you could probably just say memories. Various differences. Each individual, we see this one all the time in my office. I think it's hilarious. Okay. Basic fundamentals. Important essentials. Terrible tragedy. End result. And how about just the result instead of the end result? Final outcome, same story. Free gift, past history, unexpected surprise, sudden crisis, future plans. All right. Finally, as you are editing, so after you've done all this other stuff, you've looked for passive voice, you've looked for the nominalizations, you've fixed them where you needed to fix them, you've made sure that your subjects and your verbs are comfortably close together. Make sure that when you're spell checking and when you're proofreading, that you're looking for, on a word level, the fact that you're using the right word, okay? Our spell checkers will not replace words, okay, that are actual words, even if it's not the one that we mean to put there. So this guy is stranded on a desert island, right? Or, I mean, how many times have you made the mistake of talking about the statue versus the statute? Also, make sure that those really common mistakes that we all make, you know, the ones where you go, oh, hey, the Challenger School for Kids is smarter than I am because I didn't know the difference between further and farther, right? Learn them. There aren't that many, but if you learn them, you don't make those mistakes, okay? Things like this, 10 items or less, okay? It should be fewer because you're talking about quantifiable items. It's slide out. And that's it. Thank you so much for having me. And I will make sure that you have a copy of the PowerPoint at your fingertips so that you can use it if you'd like.
Just set my chair by you.